This is Danny Bobrow, President of AIM Dental Marketing, welcoming you to this installment of the Practice Perfection Web-Based Dental Education Series. Today's presentation is titled, Anticipating Legal Issues Vital to Dentists, Insights Not Taught in Any School, and will be delivered by Michael P. Bobrow, DDS, MBA, JD. The successful dentist must either master or have access to those with the skill and experience to navigate potentially treacherous legal and practice management waters. This presentation shows how to anticipate and avoid the many managerial, legal, and ethical challenges facing today's dentist. Dr. Michael P. Bobrow is a distinguished and multifaceted professional whose career spans nearly 4 decades across dentistry, business administration, and law. If the name sounds familiar, it's because he's my younger brother. Michael's journey in the healthcare profession began with his pursuit of a DDS degree from the University of Illinois. He has honed his skills in dentistry in diverse practice settings, with extensive experience in the nuances of different practice models, including managed care, fee-for-service, multi-specialty, and government assistance. He currently owns and manages a family and cosmetic practice in Glencoe, Illinois. His passion for improving patient outcomes and enhancing the dental profession led him to seek further education and leadership opportunities. Michael earned his MBA from the University of Chicago, graduating with honors. This equipped him with a keen understanding of business strategy and management principles. The unique blend of clinical and business management knowledge permits him to navigate the complex healthcare landscape effectively, fostering innovation and efficient practice management. In addition to his dental and business accomplishments, Michael also holds a Juris Doctor degree from Loyola University, showcasing his deep commitment to the legal aspects of healthcare. His legal expertise has proven invaluable in areas such as healthcare, compliance, malpractice prevention, contracts, and sales. His dedication to upholding ethical standards in healthcare is a testament to his commitment to both his patients and the profession. Michael seamlessly integrates his expertise in dentistry, business administration, and law to make a lasting impact on the profession. He is founder of the DDS Exchange, whose main focus is on transitioning current managed care practices to a fee-for-service model. The Exchange provides a supportive environment where individuals with varied concerns can connect with others having similar experiences. This sense of community is invaluable as it allows individuals to feel understood and less isolated in their challenges. As an attendee today, you will learn to anticipate legal issues vital to practice prosperity, avoid pitfalls related to hiring and retaining peak performers, and handle HIPAA, OSHA, and ADA, that is the other ADA, website compliance issues. Most importantly, you will learn the benefits of transitioning to a fee-for-service model and how it will improve your personal and professional well-being. While attendees are in listen-only mode, you are welcome and encouraged to submit your questions using the question, not the chat, button on the provided menu. If you cannot get to your question during his presentation, Michael has promised to do so shortly following. Attendance at today's event entitles you to apply to receive 1 1/2 hours of PACE-approved continuing education credit. Shortly following the presentation, you will receive information on how to apply to receive your CE. To be eligible, you will need to successfully complete a brief quiz, as well as note the following course number, which is BOB 113023. Once again, that's BOB 113023. And now it is my distinct pleasure to welcome to the Practice Perfection stage, Dr. Michael Bobrow. Hello, Mike.
Hello, Danny. Thank you for the nice introduction. I really appreciate it. Welcome to everyone tonight. Before we jump in, I just wanted to give a shout out to Danny and his company. Almost 40 years ago, my career in dentistry started with a 2-operatory office that I purchased even before I graduated dental school. The previous dentist in the location had sold his patient list to another dentist in town, so I purchased the old equipment and fixtures for $2,500. Excuse me. I soon realized that friends and family were not going to fill my appointment book, not profitably anyway. So I turned to my brother Danny, who had at least one of his MBAs at that time, and together we started marketing, mostly through direct mail. Encouraged by the success of these mailings, we started a small marketing company. I became too busy with my dental practice, so Danny carried on alone, building a highly successful marketing company, not only getting dentists new patients, but working with front office people, teaching the appropriate way to handle phone calls, how to present treatment, and a host of other internal and external aspects of a successful practice. So if you're in need of new patients or help with your staff and are not currently utilizing Danny's services, he is a great resource.
Well, thank you for that, Michael. I appreciate it. Did not expect it.
It's heartfelt. So I remained in my 2 operatory location for about 3 years until I grew out of it, and then purchased a building in a nearby town, which I equipped with 5 operatories. I set the practice up as a multi-specialty practice with specialists rotating in on different days. I had numerous hygiene and support staff, and I ran the practice as a complete managed care office. By that I mean I signed up for as many plans as possible. This seemed like the logical next step. What a mistake. After 7 years at this location, I was literally completely burned out. I had no savings, no retirement. I had a wife and 4 kids, and I was literally living month to month. It was really quite a nightmare. I had many of the psychological effects that accompany being underpaid at work. I dreaded going to work every morning and just wanted to get out of work at the end of the day. I was stressed in and out of work. I was seeing 30% more patients just to make ends meet, all because of managed care. I was at the point where I was ready to just walk away from the practice, when out of nowhere, a dentist, who I actually went to school with, approached me and offered to purchase my practice. It was the mid-90s, and there was a wave of dental practice consolidations occurring in the country. This is when there were significant roll-ups going on. The thought was that you could benefit from economies of scale and marketing, supplies, even lab fees. I was thrilled to sell my practice. So that's a very brief history of the hell that described the first half of my dental career. Tonight, I'm going to speak about some interesting legal issues that I have encountered over the years that can and should be anticipated by dentists. It's instructive to relate these in the context of my transition away from managed care to exclusively fee-for-service, and how you can and likely should make this transition too. I'm not going to get too deep into the law itself, but rather give you some practical information of what happens often enough in dental practices. The legal stuff tonight is interesting, but way less important than the process of transitioning out of managed care. Just to follow formalities, a quick disclaimer. Content in this presentation is not intended to and does not constitute legal advice, and no attorney-client relationship is formed. The accuracy, completeness, adequacy, or currency of the content is not warranted or guaranteed. What an attorney thing to do. So when I started my practice over 20 years ago, I opened in the same small town that I was raising my kids. I contemplated the wisdom of practicing where I live. You know, did I want to see people at Starbucks, walking at the park, going to the grocery store? But I decided to do it and never looked back. My new practice location conformed to the non-compete clause that I was contained in my practice sale contract of my previous practice. There are a few takeaways to consider when drafting non-compete clauses, both in terms of practice sales, but more commonly in employment contracts. There are usually 2 main issues addressed in non-compete clauses. One is time, and the other is distance. The purpose of these are pretty obvious. When you buy a practice, you don't want the seller opening up across the street the next day. Similarly, when you have an employed an associate, you don't want them leaving you practice with all your patients and opening up a practice next door. Now, enforceability of non-compete clauses against dental providers can vary depending on the jurisdiction and the specific circumstances of the case. In most cases, the courts look to what is reasonable under the circumstances. It should be noted that there is no federal or state law that specifies what reasonable is. Generally, enforceability of non-compete clauses comes down to protecting legitimate business interests such as trade secrets, confidential information, customer relationships, or goodwill. In dentistry, it is the customer relationship and goodwill the courts most often protect. After all, dentists spend a great deal of money and effort attracting and keeping patients. Also, the non-compete agreement must conform to public policy. Most jurisdictions will not enforce non-compete clauses that are overly broad, such as if they limit the individual's ability to work and earn a living. More practically, there are some steps you should take to protect yourself from facing competition from previous employees. First, it's a good idea to restrict access of your employee to patient data that can form the basis of competition in the future. Most important of these are all the different ways that a patient can be contacted: phone, email, mailing address, etc. Be aware that most courts frown on limiting the choice of patients to receive treatment. Therefore, no matter how a patient is contacted, it is extremely unlikely that a court would restrict the choice of a patient to see the practitioner of their choosing. Courts will not issue cease and desist orders or temporary restraining orders to block a patient from seeking treatment. Lastly, in the real world, the party with deeper pockets often will prevail in any dispute. The saying goes, you may be right or I may be right, but it's going to take you a long time and a lot of money to find out. It is important to assess the relative position of the parties. It doesn't really matter who is right or wrong if it will cost too much money to find out. On a side note, never assume that because you are using or opposing a powerful law firm that they necessarily know what they are doing. In the case of my practice sale, I negotiated the deal myself up until the closing. The opposing counsel was one of the three largest law firms in Chicago. While they included an airtight non-compete clause, they actually closed on the practice sale without negotiating a lease on my building. That is, they had paid high six figures for a practice without a legal right to occupy the premises. I worked out a deal for rent the next day, but it could have gotten ugly for the purchaser. Definitely malpractice.
And worse than embarrassing for the law firm.
Oh, so I mean, the person who purchased the practice was in a terrible negotiating situation, but like I said, he was somebody I went to school with, so we worked it out. But it was an interesting experience.
I know you did.
So I purchased a small building in my hometown and started my new practice. Starting from scratch has its challenges and its benefits. For example, there was no possibility of losing patients to another local dentist because I didn't have any. My initial mailing was 300% more successful than any I had ever done. Why? First, no one else in town was doing any direct mail. Second, it turned out that every patient in town that had any gripe with their local current dentist were dying to give me a try. Within the first 6 months, I had acquired over 200 patients from other local dentists. In one case, it wasn't even the dentist that was the problem. It turned out that the front office staff were all well hated. One of the patients that transferred to my practice told me that the front office staff was threatening collection over $20 that was 30 days late. This patient and her family had been with the previous practice for over 15 years. It's a very good idea to monitor what your front office staff is doing and saying.
Yeah, but it's also possible that they were getting they were getting their marching orders, even indirectly, from the owner.
Right, and those could be misinterpreted.
Right.
It could be that the owner said, collections over 90 days for X amount, and they took it a little too far.
Right,
so
literally.
You really have to keep
no
an eye on
exceptions.
things.
Right.
Another decision I considered when I started my new practice was whether I should compete on price and slightly undercut current competition. After debating and considering all the alternatives that I had learned in business school, I decided I would present myself as the high-quality, high-fee alternative. I don't really have time to discuss all the factors that make this business model attractive in personal service, but in the end, I was charging 25% more than my competition's full fee rates. I quickly approached my capacity with the days and hours I was willing to work. I was earning twice as much, working at half as much as I did at my previous managed care practice. I guess that bears repeating. I doubled my profit working half as much. I hired an associate for 3 days per week to handle my overflow of patients. Interestingly, she was also working at some other practices and was signed up with managed care networks at all her other offices. I confirmed that she could see patients as an in-network provider at my practice without affecting my status, so I added my office under her name. She would see all the patients referred from managed care, most kids, and anyone else I did not want to see. We entered into an employment contract, details of which will form the basis of our next look at some legal aspects that you should anticipate. First was the interview process. As you know, there are things you can and can't ask during the interview. It is essential to ask questions that are relevant to the job and the candidate's qualifications. Always avoid any question that could lead to discrimination or bias. Most of these are pretty obvious. Avoid asking a candidate's age or date of birth. Questions about a candidate's marital status, family, or plans for children are off limits. As we all know, it's nice to know as a dentist, if you're going to hire somebody, it'd be nice to know if they're going to be needing maternity or paternity leave anytime soon, but don't ask about it. You should not inquire about a candidate's gender or gender identity. Avoid questions regarding a candidate's race, ethnicity, or religious beliefs. You can, of course, ask a person if they can work on Saturdays, but you got to be careful how you frame the question. It shouldn't have any religious connotations whatsoever. Questions about a candidate's disabilities, health, or medical history are generally not allowed. However, you can ask if the candidate can perform the essential functions of the job with or without reasonable accommodations. Questions about an applicant's arrest record or criminal history should be avoided. That may be counterintuitive. You may inquire about a conviction relative to the job. An example outside of dentistry would be if you were interviewing a truck driver, you can ask him if he's ever been convicted of a DUI.
This is a little surprising to me, Mike. You can't, because it seems to me, since I've been looking at various applications for different reasons lately, most of them do ask, have you ever been convicted of a felony? But you're saying they're on thin ice there legally?
Yeah, absolutely. I mean, unless it pertains to the job specifically, I guess a good example in dentistry, if you're in a pediatric practice and you're interviewing someone, you can, are they registered as sex offenders would be a reasonable question. Although, anything like that, anyone could argue. If the answer is no, you may, you may be in some thin ice there.
Interesting.
In addition, you have to avoid questions about a candidate's financial situation. it's always nice to know if someone is motivated to make money when you're hiring them. It's nice to know, but you're not allowed to ask. It's generally not appropriate to ask about a candidate's political affiliation or activities. In general, it's best to refrain from asking for access to a candidate's personal social media profile or making inquiries about their personal life outside of work, unless it directly relates to the job. Again, that may be surprising. We all, those of us who have older children, if they post pictures of themselves, I guess, smoking marijuana before it was legal or doing other, you never want to go on your kid's college Facebook page. You're not going to leave any better for wear after seeing what's going on. But, in a professional setting, also not permitted. It's important just to focus on the candidate's qualifications, skills, experience, and job-related factors during the interview. Some key elements that should typically be included in an employment contract, besides the obvious name and address and date on the contract, the job title and description of the employee's responsibilities and duties should be included. Obviously, the location where the employee is going to work, employee's salary or hourly wage, information about bonuses, commissions, or other forms of compensation, details about benefits such as health insurance, retirement plans, and paid time off, any terms related to overtime, the expected work schedule, including regular hours and days of the week, the notice period required by both the employer and the employee for terminating the employment relationship. Now, in the U.S., and especially in Illinois, most employee contracts are at-will arrangements, which means either side can leave without any reason, but the amount of notice that should be given should be covered up front. When grounds for termination include just cause provisions, you have to be pretty specific about those. Any severance or notice pay arrangements in case of termination without cause. Finally, any and we talked about this a little bit, any confidentiality agreements or non-disclosure clauses to protect sensitive company information should be included. In dentistry, this includes patient information, marketing material, and any unique systems in use at the office. And of course, the employer and the employee should sign, date the agreement. A further consideration when starting with a new hire is to determine whether they will be employees or independent contractors. Many dentists, in an effort to reduce their portion of employee taxes owed, will treat dental associates and even hygienists as independent contractors. This can be a costly mistake. One way to decide the appropriate designation of a new hire is to apply the common law test, which is a set of guidelines used by the IRS that classifies workers as either employees or independent contractors. In a nutshell, the test measures how much behavioral and financial control an employer has over an individual and the types of relationship both parties share. A worker who meets the guidelines of the common law test is considered to be an employee. Though a business can hire and pay both employees and independent contractors, there are important legal differences between the two. Employees get income tax, Social Security, and Medicare withheld from their paychecks. They may be entitled to protection of employment and labor laws. Employers also match some of these withholdings, and that's why employers often choose to treat someone as an independent contractor. Independent contractors do not get taxes withheld. They are also not entitled to standards and laid out in employment and labor laws. Now, if you classify an employee as an independent contractor and you have no reasonable basis for doing so, then you will likely be held liable for the employment taxes retrospectively for the worker. And sometimes that can go back years. Perhaps obviously, it's far more likely that your employee will be the source of any challenge rather than the IRS audit it pays to be upfront with your new hires.
And Michael,
So,
under the heading of penalties, because I looked into this once too. Am I correct that you can also get hit for like treble damages, or there's some like triple penalty, maybe not of the amount owed?
in the case of fraud, that can be applied. Most of these can be argued as an honest mistake.
Unintentional, I see. Okay.
Yeah, and where they usually get you is when you've classified one type of worker as an employee for, a decade, and then you give a designation of independent contractors to someone who's doing the exact same job.
Yeah,
the IRS
I
kind
see.
of finds that a little bit inconsistent.
Yep. Okay, thanks.
So a few years after my associate started with me, she decided to open her own practice outside the agreed non-compete zone. We parted ways on great terms. With her departure, my office was once again fully fee-for-service. What happened next could only be described as a huge surprise. I call it the law of unintended consequences. Less than 5% of the current patients that came to our practice because my associate was an in-network provider left the practice to find an alternative in-network provider. And I continued to get new patients through insurance referrals. What was going on? Well, at least two things. First, because the insurance companies are lazy, they don't update their in-network provider list. Or because they like to have more coverage than they really do. I continued to receive calls from potential new patients that had found my phone number through the patient portal of the insurance company referencing my previous associate. All that was necessary to convert these inquiries into appointments was training my staff with a carefully worded script. In most cases, patients were more interested in other aspects of our practice than they were about fees. You can imagine that this is even more likely for patients of record. With these patients, there's already been an established relationship. I found that many patients don't even know that they are receiving negotiated rates. They just know that they have dental insurance. It has now been over 10 years since my associate moved on, and I still get around 7 to 10 new patients per month to insurance patient portals. You should know that because of this phenomenon, it is much easier to transition from managed care practice to fee-for-service than it is to start one from scratch. In some cases, you already have hundreds, if not thousands, of patients that transition to fee-for-service. When you communicate in the appropriate manner, patients are reluctant to leave over fees. I just want to say a quick word about requests for references for former employees. About 15 years ago, an employee of mine was calling in opioid prescriptions to a pharmacy for herself using a number of names. The pharmacy finally called me and indicated that they suspected that these were unauthorized, and it had taken a long time for them to wake up. And of course, I didn't know what was going on. So we got her enrolled in a rehab program, first inpatient, and then followed by outpatient. When she returned to work, she was very apologetic and thankful for the treatment and the opportunity to continue. Less than 6 months later, there was a relapse and we terminated her employment. Two things followed. First, she filed for unemployment. I was sort of blown away, but decided not to fight it, even though there would be significant financial implications for my practice from my increase in unemployment insurance rates for all my employees. In other words, the rate for every employee in my practice went up, and it stayed up for 5 years. So it turned into real money. Well, I could have fought her application. I thought that the risk outweighed the penalty. It was just a valuable lesson to learn. Here's the interesting part. 3 years after this incident, a dentist called me and said that this same ex-employee had put me down as one of her references. This incident brings up a very important question. Is there any potential liability for answering reference inquiries? For the most part, answering references honestly is generally good practice. It promotes transparency and integrity in the professional and personal relationship. While the truth is always a good defense, there may be situations in which providing honest answers could potentially lead to liability. Excuse me. For example, if your honest reference includes any arguable false statement that harms the subject's reputation, you could be liable for defamation. Providing a reference that contains discriminatory language or implications could lead to legal consequences. Generally, I don't like to put anything in writing when I'm answering a reference. Be mindful of sharing private or confidential information about the subject of the reference. Sharing sensitive information without consent may lead to privacy violations or breach of confidentiality. In the case of this particular employee, I was not prepared to share her history of addiction. In certain situations, an employee may argue that a negative reference was provided in retaliation. To minimize potential liability when providing references, take the following precautions. Stick to the facts. Focus on objective, factual information about the individual's performance, responsibilities, and accomplishments. Be consistent. Treat all reference inquiries for current and former employees consistently to avoid claims of discrimination or favoritism. If possible, seek the subject's consent before providing a reference. This can help establish the boundaries of what information you can share. Provide balanced feedback. Share both positive and negative aspects of the individual's performance to offer a fair and balanced perspective. Finally, keep records of the references you provide. Okay, a quick word about compliance issues under OSHA, HIPAA, Americans with Disability Act website compliance. This could be pretty dry stuff, but it's important to cover. I'm not going to take a deep dive into the statutes, but want to mention how to handle any potential complaints. First, let me say that complaints are generally lodged against large companies. In the case of small dental practices, 95% of complaints violations are brought by disgruntled employees or patients. Make no mistake, there are many employees and patients that know how to extort dentists. When confronted with a complaint or threat of complaint, it is important to assess the motive of the person making the accusation. Many times it's possible to diffuse the situation before it gains too much momentum. I had a colleague that started dating his dental associate. Long story short, when he broke up with her and then fired her, she called OSHA just to hassle him. Parenthetically, it's never a good idea to date office staff or patients. Obviously, the best way to defend against accusations of any type is to be fully compliant with all regulations. I venture to say no one is 100% compliant, and even those practices that are will need to address any complaint against them, which is always time-consuming. Interestingly, seldom, if ever, will an administrative agency conduct a random audit on a small dental practice. However, some managed care companies perform audits of in-network providers as part of their recertification process. If you read your in-network agreements carefully, the insurance company often has a right to audit certain areas of your practice to ensure that you are in compliance. These audits most often occur in the areas of OSHA, HIPAA, and of course, malpractice insurance. More recently, ADA website compliance, the other ADA, has become an issue, again, mostly for larger practices. These internal audits by insurance companies are easier to handle in that the insurance company will provide you with a list of things that need to be addressed. I know recently Danny has been helping several clients with their websites to ensure that they are compliant.
Yeah, and I'll just say briefly, if I may, just
Yeah.
Anyone that's interested in whether you're a health partner client that is of ours or not, you can also reach out to me for some suggestions on how and whether to ensure that your website is complying with the Americans with Disabilities Act.
That's good to know. So briefly, HIPAA complaints are handled by Health and Human Services, Office for Civil Rights. They are responsible for enforcing the privacy and security rules. Quickly, the American Dental Association HIPAA guidelines requires the dentist and their staff be familiar with the HIPAA regulations, which are designed to protect the privacy and security of patient health information. HIPAA consists of two main rules, the privacy rule and the security rule. The privacy rule sets standards for the protection of patient health information. Dentists must ensure the patient's records are kept confidential, and they must have policies and procedures in place to safeguard this information. The security rule focuses on the technical and physical safeguards necessary to protect electronic health information. Dentists who use electronic health records must have security measures in place to protect the integrity and confidentiality of the data. It is important for dentists to obtain written consent from patients to use and disclose their health information or treatment, payment, and healthcare operations. I know a lot of us, often when another office calls and wants patient records or x-rays as a favor, we'll just shoot them over or email them over. That's a big mistake. Always call your patient and get the request in writing so that you're covered. Dentists are required to notify patients in the U.S. Department of Health and Human Services in the event of breach of unsecured protected health information. The notification must be prompt. It's important to emphasize that the HIPAA compliance is an ongoing process, and dentists should regularly review and update their policies and procedures to ensure that they are in line with current regulations. Next, OSHA. 3 federal agencies comprise OSHA as a whole within the Department of Labor, the Occupational Safety and Health Review Commission, and the National Institute of Occupational Safety and Health. Here are some key points related to OSHA guidelines for dentists. Dentists must have an exposure control plan in place to protect employees from occupational exposure to blood or other potentially infectious materials. This plan should include protocols for handling contaminated sharps, providing hepatitis B vaccinations to employees, and providing appropriate personal protective equipment such as gloves, masks, and eyewear. Dental offices must have a written hazard communication program in place that includes a list of hazardous chemicals used in the workplace, safety data sheets for these chemicals, and employee training on the safe use and handling of chemicals. If dental procedures generate aerosols or particles that could be harmful to the respiratory system, dentists and their employees may need to use respiratory protection equipment such as N95 respirators. We all got familiar with these during COVID. OSHA may have specific requirements related to the safe use of X-ray equipment and the protection of patients and employees from radiation exposure. In many states have agencies that handle X-ray equipment. In Illinois, it's handled by the Illinois Department of Nuclear Safety. Dental offices should have an emergency action plan in place to address various emergencies such as fires, medical emergencies, and natural disasters. This plan should include an evacuation procedure and training for employees. Finally, website compliance through the ADA, American with Disabilities Act. 2 agencies within the Department of Labor enforce portions of the American with Disabilities Act, the Office of Federal Contract Compliance Programs, and the Civil Rights Center, which is part of the Office of the Assistant Secretary for Administration and Management. So making a website ADA compliant, American with Disabilities Act compliant, is essential to ensure that individuals with disability can access and use websites effectively. To achieve ADA compliance, you need to consider various aspects of web design, content, and functionality to accommodate people with disabilities. Some recommendations for making content accessible are provide text alternatives for non-text content such as images, videos, and audio. Ensure that all website features and functions are operable via a keyboard without requiring a mouse. Ensure sufficient color contrast between text and background to make content readable. Avoid relying solely on color to convey information. Allow users to resize text without loss of content or functionality. Provide captions for videos, offer transcripts for audios. Implant audio descriptions for videos where necessary. Ensure buttons and interactive elements have clear labels or instructions. It's a great idea to seek feedback from a user that has a disability to identify issues and improve accessibility. So, generally speaking, what do you do if you are confronted with a complaint or a threat of a complaint in any area of compliance? Responding to a complaint from a federal agency should be done carefully in accordance with specific procedures and requirements of that agency. Federal agencies have significant authority to bring and rule on investigations. These are really big deals. They kind of hold all the cards. So proceeding carefully is imperative. Some general guidelines include: collect all relevant documents, records, and information related to the complaint. If the complaint involves complex legal issues, it is advisable to consult with legal counsel to ensure that your response is in compliance with the law. Prepare a clear and concise response to the agency's complaint. Address each issue raised and provide supporting evidence or explanations where necessary. Now, this next one is really the most important. Maintain a professional and respectful tone in your response. Avoid confrontational language or defensive attitudes. Many of these complaints can go away quickly if you are cooperative and courteous. This is what happened to my colleague whose girlfriend turned him in. He explained the situation, and they almost dropped it immediately. Pay close attention to any deadlines set by the federal agency for responding to the complaint. Maintain detailed records of all communications and documentation related to the complaint in your response. This will be valuable in case of further inquiries or legal action. Submit your response to the federal agency through designated channels or methods specified by the complaint. Don't mail letters or send emails if the federal agency wants you to communicate through the agency website. Very important. They'll never find it. After submitting your response, follow up with the agency as needed to address any additional questions or concerns they may have. Always keep the line of communications open. It is essential to tailor your response to the specific agency's requirements and the nature of the complaint. A word about malpractice claims. As far as malpractice allegations and claims are concerned, I kind of want to look at it maybe from a little different perspective than usual. First, who usually brings these claims against dentists? Obviously, the longer a patient has known you, the less likely they are to sue. Current patients seldom sue about any treatment. Most often, it is the way you handle any patient complaint that makes all the difference. We all have patients that we dread seeing. Never show anger or be dismissive when these patients complain. When a patient feels that they are not being treated fairly, they are more likely to consider legal action. A common source for contemplation of legal action occurs when a former patient sees a new dentist who criticizes your treatment and stirs them up. Most successful claims against dentists deal with undiagnosed conditions. Periodontal disease is a common example. More recently, however, with all the gains in imaging available beyond simple x-rays, the potential for other undiagnosed conditions have arisen. It is critical to realize that in many cases, the dental practitioner is responsible for any malady that appears in an image they have taken. Make sure you are well versed in diagnosing. At least know when something appears concerning and refer to the proper specialist. So an analysis of the stakeholders in a lawsuit is instructive as to how things often turn out in a malpractice suit. First, it is important to remember that an affidavit from a dental expert must accompany the initial complaint to the court. It's not that easy to find an expert that's going to say what you want, and they can be awfully expensive. So the plaintiff's attorneys want a fast settlement. Most often they're not getting paid by the hour. They've taken it on contingency, and they don't want to deal with a low damage case, although it's usually possible to find some attorney who will take a case. Often they'll drop the case if there's not a quick offer. Clients that bring low value cases are usually a major pain in the neck relative to large damage cases. They're the kind of people who call every day saying, how's my case going? How's my case going? Just looking for a quick recovery. Attorneys are reluctant to front money to experts if there's not potential for significant award or damages. Now, I'm referring to smaller cases where, maybe a crown fell out or something like that. We're not talking about anesthesia cases where there's brain damage and stuff. Obviously, those are totally in a different ballpark. But generally speaking, the plaintiff attorney does not want to deal with any headaches. The malpractice company, your malpractice company, may want to settle quickly or slowly, depending on who's representing them. Some malpractice companies hire dentists on a case-by-case basis and pay them by the hour, and generally they want those cases settled pretty quickly. Other insurance companies hire attorneys that handle every case, by the year, and the insurance companies are not that much in a hurry. The insurance company attorney is the same analysis. If they're getting paid by the hour, they don't mind slowing things up. If they've been paid a fee for the year, they want to move things along quickly. The patient always wants a fast and big recovery. Now, from the doctor's point of view, it kind of obviously depends on the case, but so you need to gauge the merits of the case. And another analysis is your ability to handle anxiety. Some doctors would rather be done with it fast, not deal with it. It eats into their psyche. They can't sleep. It's interesting to note that most malpractice policies that you have allow the dentist to decide whether to settle or not. So that's got to be part of your analysis. If you're going to lose sleep, and that's part of the calculation. If you settle a case, it ends up online, and there'll be a notation, usually in the Office of Professional Regulations, that you have been sued, which can be not great for your practice. I often tell clients who are faced with malpractice cases to play it so slow, reassess along the way. Lots can happen. I once saw a frivolous case where the expert actually died along the way, and the attorney just dropped the case. One last note with malpractice cases. While generally rare, the plaintiff can collect beyond the limits of insurance coverage. This is true even if the dental practice is informed as a limited liability entity, such as a corporation or an LLC. It's called piercing the corporate veil, and it allows the plaintiff to get to the doctor's personal assets. I'm not going to get very deep into this, but it needs to be part of the calculation when deciding how to proceed.
Yeah, what I've understood is that smart attorneys have often done a little research to determine, from the point of view of the defendant, of the doctor, what the nuisance fee that they can ask for is, which is basically, at the end of this whole thing, how much are you going to end up spending to defend yourself, or just time and distraction, and that's what they ask for, just to make the thing go away. Have you experienced or seen that as well?
Yeah, it's a little different in medical cases because there's not like a deductible to the doctor. Generally speaking, any award is going to be covered by insurance, 100%. Now, of course, your premium.
Where does piercing the corporate veil come in, though? Because that's a possibility, right? And then, I mean, if they pierce the corporate veil, then you're not covered, right? Or am I mistaken?
No, you're absolutely right. But the limits of coverage, let's say, are usually $1 million per incident. There's very few things in dentistry that even get close to that. You can pierce the corporate veil if you haven't followed formalities with your corporation, and the court determines that the corporation and you are the same person. A perfect example of that is when you're like paying your mortgage through your office checkbook. If you're, any commingling of funds between your personal and your corporate entity will void that separation.
That's a really important consideration or an important takeaway for our viewers, I would say.
Yeah, I mean that also could. I mean, when you have a limited liability company, most creditors cannot get to you. If you order a ton of supplies through your corporation and you decide not to pay, they have to sue the corporation. They can never come after your personal assets. However, if you've commingled funds and they have a sharp attorney, they can. And then obviously there's no insurance involved with that.
Good advice.
There's no insurance for not paying. So I'm going to spend the remaining time we have tonight talking about the DDS Exchange, which is a company I started and you mentioned that helps transition managed care practices to fee-for-service and how it can transform your life. Hopefully we'll have a little time to take some questions after. Our mission is to empower dentists facing burnout and unfair compensation, fostering healthier boundaries, self-care routines, and mental well-being, enabling dentists to provide superior patient care through a fee-for-service model while achieving a balanced and prosperous personal and professional life with at least 50% reduced workload and 100% increased earnings. Our program is not for everybody. We work with patients who own their own practices, have been in practice for more than 3 years, are suffering from burnout, are unmotivated, dread going to work, and being undercompensated. They recognize managed care as a race to the bottom and have mindset to do whatever is necessary to change. So we work with people who are very unhappy with the compensation rates that they're receiving and feel they deserve more. Our outcome guarantees that if you follow the program, do the work, ask for help when you need it, you'll be working 50% less and making 100% more. It's an 8-week program customized to your current practice situation. After the 8 weeks, we are available as needed to support you. Best of all, we do 90% of the work for you. So for those taking part tonight in the webinar, I'm offering a no-charge 1-hour call so that you can find out how the DDS Exchange can transform your life. You can schedule the call through Calendly at the address below. I think Danny might be able to provide that in a little better.
Yes, don't worry about jotting this ugly link down, folks.
For those of you who can't memorize that, we can't work with you.
Yeah, right. Well, your memory is legendary, but I bet, maybe you could remember it because you wrote it. But I have indeed already sent it through the chat link, and the post-event email that will send you instructions on how to receive your CE will also include this link, so not to worry.
All right, I really appreciate it. Thank you, Danny, for the opportunity to present tonight. I think we may have time for some questions, but you'll let me know.
Yeah, we do indeed. And thanks a lot, Mike. That was very succinct. You covered a great deal of territory. And while some of it may not be the most exciting, it is nonetheless very important. And that's why I was glad you accepted my invitation to come on the platform this evening. Let's indeed move on to questions. The first one being, what is considered the most difficult step in transitioning from managed care to fee-for-service?
Well, we found that it's the mindset of the doctor that's the most important thing to transition. In your practice and in your life, whatever you picture happening in the future will happen, whether it's good or bad. So your outside has to match your inside. If you believe that you deserve to be receiving higher reimbursements for your work, if your work is great, you have to truly believe it. No one's going to ever buy into someone who isn't sincere about what they're doing. So what we go through usually in the initial consultation is where you're at in terms of your frustration level with managed care. There are actually many dentists who are somewhat happy doing managed care. It's a low risk, low reward place to be. You don't have to worry about patients leaving you. You're not charging a lot. They have to come to you. You go home and you go on your way. But when you really believe deep down, and your mindset tells you that you deserve better, then that's the most difficult transition for most managers to make.
Well, I think it's also the case that you have to truly believe that your patient deserves better as well. That, with these plans, it's often not possible to invest in the highest quality equipment or supplies, equipment, education even. So I think it's a two-sided coin.
Yeah, no, that's a very important point. And it's something that we talk about with patients who are considering leaving the practice, that managed care offices have got to be cutting corners somehow, because in this day and age, with the cost of quality, supplies, equipment, staff, it's impossible to make a profit charging the fees, these negotiated fees that frankly keep going down every year.
Mm-hmm. Well, I've seen this evolution, in your career, and so it's been. I think they say Henry Ford said, "Whether you think you can or think you can't, you're right." So it really is all about your set of beliefs.
That's it. That's well said.
All right. Well, I wish I coined it. Second question. It seems as though every dental practice in my area is an in-network provider. Am I at risk of losing my current managed care patients to these other practices if I drop my current managed care affiliation?
Okay, so the short answer to that is no. We touched on it a little bit tonight. You will find as you begin your transition out of managed care that most patients come to you because of your relationship and things other than fees. And when you think about it, if you give a painless shot, if you're available for emergencies, you respect their time, and you have the right verbiage to talk to them about, they don't want to leave. It's very difficult to leave a comfortable practice that you're happy with, and find someone for other reasons. And I touched upon it. Most of our patients who have dental insurance know that they're getting some of their treatment covered. They don't know about negotiated rates. They don't know about the percentages. And frankly, most of them don't even care. So when my in-network associate left, I was expecting a massive exodus from the practice. And 95% of the patients stayed, and my fees were considerably higher than hers, and it wasn't a factor.
That's very enlightening for a lot of people. Yep. And a pleasant surprise. Did you want to add to that?
I was shocked. No, I was just going to say that it certainly applies to the patients that you already have. That's a no-brainer.
Mm-hmm.
What the biggest surprise was, the people that would call through the in-network portals, and when we explained how we handled things here, they still came in. So that's even more proof that fees are not the end-all for the decisions the patients make of where to come.
Mm-hmm. I think it might even be accurate to say that while patients may join you because of your affiliation with managed care, that's not why they stay with you.
That's very succinct.
All right, next question. If I'm interviewing for a front office position whose responsibilities include marketing, is it still inappropriate for me to ask for his or her social media handles?
Yeah, unfortunately, or just fortunately, you have to distinguish between office and private emails, websites, etc. It is certainly appropriate to monitor what she's doing, perhaps through a chat room that you have for your office, or a Facebook page that you have for your office. That is 100% reasonable. What you can't do is monitor anything that she does outside of the office. You're setting yourself up for all kinds of liability. So yeah, as long as you separate the two, that's fine. But you have to stay from any privacy issues.
Yeah, because you won't be using their handles anyway. They're going to be using as you said, the practice.
Right.
All right, next question is a easy one. Are you a provider for PPO insurance?
Currently, I am not. I do take people who have PPOs, but I always explain that I'm not in network, and we talk about how things are, how payments are handled here, and they understand what it is that separates our practice from somebody else. We go out of our way to make sure that they know that we are not in network.
Yeah, I mean you don't hide that fact, but I've listened to your team and you've got them well trained to explain why it's in their interest and why you've made the decision to be insurance independent. But that doesn't mean that you don't process the paperwork. You just simply tell them that they get paid directly they get reimbursed by the insurance company. Right?
That's right. And during the initial call, if they're just looking for a local dentist on a certain day at a certain time, we'll book the appointment, explain as necessary when they get here. If somebody calls up and asks directly, are you in network for our PPO? Honesty is critical in any communication, especially in medical. So we just explain exactly how it works in this office and that we're not part of their in-network.
Okay. We got a number of questions remaining, so moving on. You mentioned there are certain practice qualifications that must exist to transition from managed care to fee-for-service. Can you discuss further what is necessary?
Well, I'm going to go back to the mindset. That's critical. I'll also mention that certain practices are not conducive to the transition. Offices that take HMOs, which require you to see certain dentists. Capitation plans, you usually have to see a certain dentist. If you are an extremely poor or depressed economic area, generally it doesn't work. But other than that, pretty much any practice can transition from managed care to fee-for-service with the proper instruction, scripts, and systems. It's usually pretty flawless.
Right. And in your consultation, I mean, you ask specific questions so that you can get an idea of what the environment is in which the doctor is practicing, and then sort of provide them with a more or less pretty firm determination on whether this could work or not, right?
Yeah, we do a very substantial deep dive into everything that's going on in the practice. I mean, oftentimes it's usually 2 or 3 office policy changes to make the transition seamless. But we need to know, for example, if a doctor's living day to day, you may not want to transition too quickly. Sometimes we find out that the doctor's overhead is really unreasonable. Some practices have 3 people working the front desk, 3 assistants, and they're not even busy. So there's a lot of things that need to be taken into consideration, and we do consider everything.
Next question, sort of related. Are you saying it is not possible to be profitable as a managed care provider?
Well, let's define. If profitability is defined as revenues exceeding expenses, you can be profitable. I would use the word adequately profitable. You're a dentist. You put in your time. You're providing a technical skill that very few people can. I feel, and most dentists feel, that they should be compensated beyond technical profitability, through a fee-for-service model. Again, I touched upon a little bit. There are some doctors that are very comfortable without being under pressure, with higher fees. Expertise is expected, and you can make money in the managed care model. I don't think you could make a fair return.
Okay, I have a question for you, my own, which has to do with HR. I know that it's important to have an employee handbook, and it's also important that you communicate when it's updated. I've been told that you need only let somebody know that there's been an update and that they can access the update online and look at it. In other words, they don't have to sign that I, hereby attest and affirm that I have read your recent update. Not that you're trying to hide anything, but, people, it's these days with the fine print or privacy policies, which usually mean you don't have any privacy. They're so voluminous and such small type that people don't bother reading them. But what's your, advice for employee handbooks, how to handle them and communicate them best?
Yeah, when we change policies in this office and add it to the handbook, we generally have the employee sign off on it. That's particularly true if it, affects them directly. In terms of bonuses or termination clauses, those are really important for employees to sign off on. If you're changing your hours of operation or putting, adding equipment, we add that as, physical change to the office, but we don't ask that our employees sign off on that.
Right. So you do go to the trouble of actually printing it out and then adding it as an amendment to the or an addendum to the handbook and actually have them sign off on the change. Very thorough.
I mean, it's only been, I was, for sure since I became an attorney. I mean, in my early years, I didn't have an OSHA handbook. I didn't have a HIPAA. I don't even, to this day, I don't have a website section. It hasn't been much of an issue. I haven't taken new patients in a number of years, so I don't even, for a long time, I didn't even have an external website. but it can be enough of a hassle being confronted, and again, it's usually by an employee or a patient, to have things in writing. It's a great start if somebody shows up. At least you're pulling out something, and they know you've considered it serious.
Yep. Yeah, that goes even as far as the tone and respectful attitude, showing that because you're already showing that you respect the process by having committed to that. Absolutely
so
agree.
Important.
What's the most unusual or unfair malpractice claim you've ever heard of or experienced?
That's a really good question. Well, I'll tell you a story that didn't end up in a malpractice case, but was pretty interesting. I had a patient that I had done some work on, and she was experiencing some discomfort for I don't know, a week or so. And I said, it could take 7 to 10 days to settle down. And she came in for an adjustment, and I asked her, and she asked me, when is it going to stop hurting? And I said, is it hurting still? And she said, no. So I looked at her and I said, well, I guess never.
It's never going to not stop not hurting.
It was pretty interesting. And, she didn't flinch. I didn't flinch. And that was the end of it. I mean, at some point I was thinking, people just get something on their mind, and
it's like, if it hurts, when's it going to stop? Yeah, that's really odd. I've heard, because I've attended some courses on like cone beam, that if you do have a cone beam and you use it, you're actually no pun intended, exposing yourself to greater possibility, or at least a higher level of care, because now you're scanning the entire or a larger part of the cranium, and if there are suspicious lesions even outside of the oral cavity, that you could be exposed to liability if you miss those. That's what I've heard.
Yeah, and that's 100% correct. I touched on it a little bit. In the old days, it was undiagnosed periodontal disease that got many dentists into trouble. Right. Again, if you're taking these expanded images, you are responsible for everything in that image. And, even with Panorex, as I've gone through my 40 years careers, there's a lot of stuff going on that I don't know what it is. If it looks, oftentimes suspicious things look suspicious. But it is very important to at least get the person to the correct specialist if something doesn't look right, because you will be held responsible. The insurance company will be settling that case for you if it's something significant, no doubt.
Okay. Oh, that's interesting. One thing, it's more of a comment that I wanted to make than ask a question, but obviously I want your take on it too, Mike, is that when you're talking about HIPAA compliance, there are rather cost-effective encrypted email services that you can and probably should use when you are transmitting protected health information. Even if you have the approval of the patient, my understanding is that you're in a much better position if you're encrypting and using HIPAA-compliant encryption services, which are available, and actually we can help connect people with those services if they're interested. There are also entire crisis management teams that you can subscribe to, services that will set up the telephone hotline and do the press releases, and if there is a breach. So I just want to make sure everyone in attendance is aware that those services do exist. And, whether and when you want to secure those services, it really depends on sort of your risk tolerance, really, how comfortable you sleep at night. And some of that depends on where you're located, too, which sort of leads into the next question. But if you want to comment on this before I move on, Mike, please do.
Yeah, I did I mentioned that HIPAA compliance is an ongoing process. It's another great point. As technology changes, you are responsible for updating your technology, and encryption is a great example of that. In the old days, we would send things just over the email, and that was that. When breaches occurred, solutions were developed, and you are now responsible for updating your systems to comply with, the latest technology. You could be held liable for not using the latest. It's kind of the standard of care issue that we're held to when we do any procedure. The standard of care now in HIPAA is that the material is encrypted.
Right. And here's a final question actually we've got time for is concerning website compliance. Need one recreate their entire website to be website compliant? Do you want me to take that one?
Yeah. Yes.
Well, the answer, the good news is that you don't. There are actually services, and that's how we work with it. We can install code that will provide the opportunity for a web visitor to specify what their condition or situation is, their disability, and push a couple buttons to ensure that they're able to then view your website. There's even one for people with epilepsy, prone to seizures, to make sure that there's no flickering or strobing or any kind of special effects that can trigger that for them. In terms of whether you want to ensure your website or achieve ADA compliance with your website, it again sort of relates to your risk tolerance as well as where you're located, because some states are a little bit more, I don't know if heavy-handed is the right term, but they're a little more strict in terms of these issues. But it's also the mindset of the patient. Frankly, we've had much more interest and have complied with our and have conferred with and agreed with our health partners in California, for instance, that they're going to want to set up an ADA compliant site sooner than later. So that's my 2 cents on that. And it's not a painful process, and it's not particularly expensive either. You can typically get a subscription for $50 a month or less, and our coders can get that done within a month's time.
And that's great for practice reputation as well. You could promote that.
Well, they refer to, if you're working with a particular person with a given disability, they're usually parts of community, members of communities who share the same disability, and they communicate.
Yes.
So it's an opportunity to get more referrals. All right. Well, again, I want to thank you, Michael. I appreciate it very much. I know the time went fast, and you covered a great deal of information, and I hope that people will take advantage of your generous offer for the 1-hour consultation. They'll be glad if they do. And just want to remind everyone, in a few days, you'll receive an email detailing how to apply to receive your 1 1/2 hours of CE, as well as that link, which is also in the chat box, and to request your complimentary managed care transition consultation with Michael. I hope you all have a safe and healthy holiday, and ask you to stay tuned for news of future events. Until then, this is Danny Bobrow, thanking you for your commitment to practice perfection. Goodbye, everybody.